Okay, we're streaming. Shannon, could you put us on the record?
Yep.
This is the matter of Brown versus Fletcher. Mr. Helderly for the plaintiff, Ms. Fleming for the defendant, and both parties are also present. And my understanding is, Ms. Fleming, that the parties have reached an agreement.
We have, Your Honor, and I will go forward with those terms.
Okay,
The parties have one minor child, Isaac, who is 3 years old. In settlement of Mr. Brown's petition regarding parenting time, we agree as follows. Mr. Brown will have Isaac in his care from now until Sunday, June 13, 2021 at 7 p.m. At that time, Ms. Fletcher will pick up Isaac from his father, and she will have him until Tuesday at 7 p.m. And at that time, Mr. Brown will pick him up from her. Ms. Fletcher will then pick up Isaac from Mr. Brown on Thursday, June 17 at 7 p.m. And then commencing Sunday, June 20, 2021, the parties will exercise the 2255 schedule such that Ms. Fletcher will have Isaac from Sunday at 7 until Tuesday at 7. Mr. Brown will have him from Tuesday at 7 until Thursday at 7. Ms. Fletcher will have Isaac from Thursday at 7 until Tuesday at 7. And then Mr. Brown will have him from Tuesday at 7 until Sunday at 7. Therefore, the party commencing his or her parenting time will pick up Isaac from the other party. They will exercise holidays pursuant to the Jackson County Friend of the Court Handbook. And we recognize that Sunday, June 20th, 2021 is Father's Day, and Mr. Brown will pick up Isaac from Ms. Fletcher's daycare provider on Sunday. He anticipates sometime in the morning. And then Ms. Fletcher will pick Isaac up from his father at 8 p.m. pursuant to holiday hours in the handbook. Each party may also have Isaac with them for 2 non-consecutive weeks during the summer being defined as June, July, and August, because Isaac's not yet in school. 1 week consists of 7 overnights and includes that party's regularly scheduled weekend. Ms. Fletcher will choose her weeks first in odd numbered years, and Mr. Brown will choose his weeks first in even numbered years. Since we're already into the summer, this year, my client will give her notice of weeks by Monday, June 21, 2021, and Mr. Brown will then give notice of his weeks by July 1, 2021. In future years, as in the Friend of the Court Handbook, the first parent gives notice by April 15th, and then the second parent gives notice between April 16th and May 1st. And a failure to give notice in your allotted time slot doesn't mean that you lose your weeks, simply you lose the opportunity to go first. The parties are both Department of Corrections employees. If they're mandated to work overtime, the parties agree as follows. If on an alternate Sunday, if Ms. Fletcher is mandated to work, Isaac will spend the night with his father, and she will pick Isaac up in the morning before Mr. Brown goes to work. On Tuesdays, if Mr. Brown is mandated, he has made arrangements to have somebody pick up Isaac from Ms. Fletcher at 7 p.m. On Thursdays, if Ms. Fletcher is mandated, Isaac will spend the night with his father, and his father will drop Isaac off to Ms. Fletcher's daycare provider before he goes to work on Friday. We will also include a provision such that the parties shall communicate regarding any changes to their work schedules. And if they're unable to reach an agreement as to any modifications in the parenting time schedule, they shall first be referred to the Friend of the Court for mediation. And if they are unable to resolve any conflict there, then either party may file a motion to be heard by the court.
Mr. Hilderly, can you confirm?
Yes, Your Honor, that is the agreement that we have reached.
Do you wish to question your client about his understanding of and acceptance of that agreement?
Yes, Your Honor.
Go ahead.
Thank you. Mr. Brown, were you able to hear Ms. Fleming's reading of the agreement that we've reached?
Yes.
And Ms. Fleming put that into email form, and I forwarded that to you, and you and I discussed it prior to this hearing, correct?
Yes.
And you are in agreement with this parenting time schedule, and you believe that it's in the best interest of Isaac?
Yes.
Thank you, Judge.
Thank you. Ms. Fleming?
Thank you. Melinda, you heard the terms as I recited them on the record,
Correct.
and do you understand those terms?
Yes, ma'am.
And do you agree to those terms?
Yes, ma'am.
So we participated in lengthy settlement negotiations, is that correct?
Correct.
Through my communication with Mr. Hilderly, and you had some communication with Mr. Brown, correct?
Yes.
And do you believe that this settlement is in your son's best interests?
Yes.
And you can live with these terms going forward rather than having a hearing today?
Correct.
Are there any concerns or comments that you would like to address to the court and to Mr. Brown?
Yes.
Please.
I did want to let you know, Judge, that I have tried to communicate with my son's father. I know this last time we had court, when I had returned to work the next day, they had sent out an email, which was on May 19th, about new days off that you can bid on. So I had noticed that there was a Monday, Tuesday. So I had put in an email that I was interested in that. So then my son will be with me Mondays, Tuesdays, be with his father Wednesday. So I was awarded those days. And I did let the plaintiff, Van Brown, know that. There was also the 2 parenting schedules that I had put together that had reflected our days off as well. He was in denial of, or not accepting, I'm sorry, let me rephrase that. He was not accepting of either of the schedules that I had presented. And he stated that he was going to present me with a schedule, but the schedule he presented had our old days. It didn't reflect anything with me having Mondays and Tuesdays. And then one of my concerns was when he had made the comment about, what's really important to me. What's really important to actually both of us is being able to have time with our son. I felt a little disrespected when he had asked me if it's really important for me to have my son on both of my days off. And he already knows that that's important to me, and it's important for him as well. Another concern I have is I had asked him, I know my Monday, Tuesday had started last week, but I had asked Van if I could have Isaac Monday and Tuesday this week, and he told me no. So he took Monday and Tuesday off from work, knowing that I had asked him to have my son, and he would have him, today and tomorrow because he's off. So again, I have missed out on parenting time with my son. And I know he was asking about wanting to swap weekends. And I had explained that, I have things that I do on my weekends currently. And my daycare provider was not able to switch the weekends, like alternate weekends. And he had gone behind my back yesterday and he had contacted my daycare. And again, I felt disrespected and just the lack of communication. And I do have messages if the court needs to ever see those. My attorney has copies as well. just kind of showing and explaining the communication between my son's father and I. And I really do try to get along with him. But it's very challenging. So I do want the court to know that I really do try, Judge. I really, really do. Because it is important for Isaac to know that his parents do get along. But he makes it very challenging for me.
So, Mr. Brown, I muted your channel. I'm assuming that's your son that I'm hearing in the background. Let me unmute.
At this moment, it was my daughter.
Your daughter, okay. I knew it was a little one, so anyway, I'm grateful that the parties were able to reach an agreement. I think it's always better. I could have given you something that neither one of you liked. Working together to try to resolve this sort of thing really is in your son's benefit. I would encourage you both. Whenever you come to court, unfortunately, it raises the level of tension. You spend money on lawyers, and nobody's ever happy about that, except the lawyers, but they have work to do. So, I would just encourage you. Clearly, there's been some, in any breakup, there's animosity. Hopefully time heals that. But even when you're feeling disrespected or angry at the other, you need to work very, very hard, both of you, to put that aside so that you can co-parent collaboratively. You're both in employment where it's potential that your schedules are going to change again, maybe at your bidding or maybe against your will. I would really encourage you to work hard to try to work this out without court involvement. But if ultimately you're not able, I will be available to resolve it. So I just want to encourage you both going forward, as best you can, put aside the contempt, disrespect, whatever it is you feel for the other. And when you look at that other parent, don't look at your ex boyfriend or ex-girlfriend. Look at your child's mother. Look at your child's father, and view each other in that context. Not it's whatever your past relationship was. Your child is going to do better when each parent does better. So keep that in mind. Wish you both well. I do want to commend the lawyers for a good job reaching resolution. You've both been well represented. I will look forward to receipt of that order.
Great. I'll draft an order and get that over to you, Brian.
Thank you, Judge.
Thank you, everyone. Have a
Thank
good day.
you.